My case is the People v. Berry, case number CAL.APP.4TH778-1991, presented by Nicole Harvey, St. Petersburg College, class number ATE 3515, Legal Ethical Issues in Veterinary Technology. Instructor Carly Taft. Docket number H006844, People v. Berry, tried in the Court of Appeals of California, 6th District. The appeal was decided on December 11th, 1991. Parties involved were the plaintiff and the respondent, the people, the defendant and appellant, Michael Patrick Berry, and the judge acting PJC. Attorneys in the case: for the defense, Jeffrey M. Evans, and for the plaintiff, Daniel E. Lundgren, Attorney General, Richard B. Eaglehard, Chief Assistant Attorney General, John H. S., Assistant Attorney General, David Law, Deputy Attorney General, and Jeff Bryan, Deputy Attorney General. The original case, the People v. Berry, case number H006844, was tried in the trial court of Santa Clara Superior Court, trial case number 117825. Presiding judge over the original case was John Flaherty, and the original judgment date was 2/16/1990. Facts of the case: the defendant, Michael Berry, lived on Wright Avenue behind the victim's home, and they shared a common driveway. The defendant owned 3 pit bulls, Blondie, Pee-wee, and Willie. The defendant told the victim, James Soto's mother, Yvonne Nunez, that his dog would not hurt her children. The defendant, Michael Berry, also told James Soto's uncle that his dog, Willie, was vicious and dangerous and could do a job on certain people. Michael Berry had a wedge that he kept at his home to pry open Willie's mouth if needed. The defendant was known to be involved in dog fighting. The defendant, Michael Berry, bred Willie for his gameness and wind and had a hard bite. The defendant would train Willie at his home on a treadmill to condition him and had stated that he would not fight him for less than $500. Willie was kept on a chain leash on the side of Berry's home between the house and the shed. Facts continued. On June 13, 1987, James Soto, 2 years old, was mauled to death by the defendant Michael Berry's dog, Willie. On that day, James Soto had been placed on the fenced patio behind his parents' home to play, while his mother, Yvonne Nunez, tended to one of her other 2 children. The victim had wandered out of the patio, went by a neighbor's home who was outside watering her garden, and to the defendant's home, where he was seen by the defendant and his roommate on their porch. James Soto eventually made his way to the corridor where Willie was kept between the house and the shed. James Soto's parents, Yvonne Nunez and Arthur Soto, realized that James was gone and went looking for him. Mr. Soto eventually walked to the defendant Michael Berry's house, where he saw Willie mauling his son James. Michael Berry was then called out by Mr. Soto to the yard, where he retrieved James's body. James unfortunately passed away the next day. Michael Berry was found guilty of the charges of involuntary manslaughter, Penal Code 192, keeping a mischievous animal Code 399, and keeping a fighting dog, which was Code 597.5. He was also found guilty of cultivating marijuana under the Health and Safety Code 11358, as he had over 200 baby plants in his yard the day James was mauled. The issues. The defense claimed that the plaintiffs were biased towards pit bulls. The defense also claimed that the plaintiff failed to satisfy their burden to prove the guilt of Michael Patrick Barry beyond a reasonable doubt. The defense claimed the victim's death to be an accident. The defense also claimed that Willie was harmless to children and was not a fighting or a guard dog. The defendant, Michael Barry, claimed that he was not aware of Willie's violent tendencies. It was questioned whether the trial court erred in instructing the jury regarding a minor's ability when under 5 years old to take precautions. It was also called into question whether the trial court erred in their definition of mischievous. And finally, it was questioned whether the dog bite statute defined the defendant's duty towards the victim, James Soto. Reasoning and rationale. The trial court instructed the jury that a minor under the age of 5 years is, as a matter of law, not required to take any precautions which the circumstances permitted, nor which a reasonable person would ordinarily take in the same situation. Being that Michael Barry was fully aware of what Willie was capable of, it was, in fact, his responsibility to provide protection to anyone entering his property. The dog bite statute was in place to protect victims from being bitten, except those who were trespassing. While James Soto was on the property without permission, Michael Barry saw him and should have done something with him before he made it to Willie. Also, because James Soto was under 3 years of age at the time, he was not able to determine the danger he was in, and therefore it was up to the owner of the animal, Michael Barry, to protect him from his known to be violent dog, Willie. Michael Barry was raising and training dogs, including Willie, for their ability to fight. He was aware that Willie may not release when fighting and kept a wedge at his home to open his mouth. The decision. On December 11th, 1991, the decision to uphold the original judgment was affirmed. In the original case, the defendant was found guilty of involuntary manslaughter, keeping a mischievous animal, keeping a fighting dog, and cultivating marijuana. My analysis of the case. My analysis of the appeal for People v. Michael Patrick Barry is that the people in this case met their burden of proof for the charges of manslaughter, keeping a mischievous animal, and keeping a dangerous dog. The idea held by the defendant that the victim, James Soto, or more so his parents, Arthur Soto and Yvonne Nunez, should have protected their child from Willie is absurd. If you choose to keep a dangerous animal, you are choosing to deal with the ramifications of that animal's actions should something happen, and therefore should have taken precautions. I agree that you should keep an eye on your children. However, I don't believe that Yvonne Soto thought her actions of placing James on the porch would somehow lead to his death that day. While I do not condone dog fighting, if you have an animal for that reason, you should be containing them better than keeping them on a chain in the backyard. They should be confined to a kennel or a run with a lock to prevent escape and injury. That includes any dog that could potentially be dangerous. The trial court provided the Webster Dictionary meaning for the word mischievous. The original jury could have been swayed by the definition. The Webster definition contained capable of causing or tending to cause harm. The defense argued that they could have taken this to mean Willie was mischievous because he barked. While this might have influenced the jury, the definition for mischievous under Section 399 stated that a mischievous dog is one that may be dangerous to others if allowed to run free or kept in a negligent manner. Therefore, either definition could be considered accurate in this case. Based on the conditions that Willie was kept, there was negligence on the part of Michael Berry. Based on this information, I agree with the court's decision to affirm the previous decision. My references.